Well, good morning, everybody, and a very, very warm welcome to BDB Pitmans employment webinar on the do's and don'ts of returning to the workplace. For those of you who don't know me, I'm Nick Lariche. I'm one of the partners in the employment team, and I'm delighted to be joined by a stellar panel of speakers today who will each be looking at a different aspect of the return to work process. You'll be able to see the panel members on the right-hand side of your screen. I think over 100 of you will be joining us today, which is great to see, but not surprising given how much there is and there will be to think about in this area. In a moment, I'll hand over to Alan Davis, who will look at the health and safety obligations you have to returning staff in light of COVID-19. Tim Hayes will then look at some of the employment issues that you may be encountering when staff return to the workplace, before Aston Hawke discusses the new rules on the government's job retention scheme and what flexible furlough really means. Finally, in the coveted end of session slots, Brian Gegg will be looking at the things you should be thinking about when you're restructuring your workforce. Brian has promised a reference to magical creatures in his talk, which I've never really thought about in relation to redundancies before, so I'm really intrigued to see how he's going to weave that in. If I can just turn to a couple of housekeeping points before we start. At the bottom of your screens, you'll see the familiar Zoom functions. And can I point you to the Q&A function in particular? This is where you can ask questions about what we're talking about today. And we'll try to deal with these questions at the end of each segment and altogether at the end of the session, especially where particular themes have been coming up. If there are questions that we haven't had a chance to answer during the hour, then we'll post the answers together with today's slides and a recording of the webinar on our website in the next few days, and we'll send you all a link. But I'm hoping we'll get through quite a few questions. So please do ask as many questions as you like. If you're thinking about something, then I'm sure someone else will be too. And please do use the Q&A function and not the chat function to do this. I think those are all the main housekeeping points. Thank you again very much for joining us. I'll now hand over to Alan Davis to look at the key health and safety points. Alan, over to you.
Thanks very much, Nick, and good morning, everybody. So I'm a partner in the firm's litigation team, and I deal with the defence of all kinds of liability claims on behalf of businesses, organisations and insurers, and I also advise on health and safety regulatory compliance issues. And I'll be talking about some do's and don'ts from a health and safety perspective for employers. Could we go to the first main slide, please? Thank you very much. So I'll be talking about, firstly, the legal framework, which is already in place, so pre-COVID, and then I'll be going on to deal with the implications of COVID-19, risk assessments, and what that looks like. So from a fundamental perspective, the employer's obligation is to protect people from harm. And this includes taking reasonable steps to protect your workers and others from coronavirus. And the obligations, which are also under common law, are enshrined in statute under the Health and Safety at Work Act, whereby under Section 2, there is the obligation set out for obligations owed to a workplace's employees, and Section 3 of the same Act deals with similar standing of obligations to other persons. So that can be members of the public, visitors to the workplace, contractors, etc. And no doubt most employers will have already built up a considerable library over the years of health and safety related documents, including risk assessments and health and safety policies. But under the Management of Health and Safety at Work Regulations 1999, employers have a specific duty to undertake risk assessments of work activities that may have a risk of injury. And under these regulations, the minimum that you must do is identify what could cause injury or illness in your business, which are the hazards, decide how likely it is that someone could be harmed and how seriously, which is the risk, and then take action to eliminate the hazard, or if it isn't possible, then to control the risk. Next slide, please. So, dealing with risk assessments, and as I say, risk assessments you've probably already got in place for a multitude of different tasks and activities in the workplace. This can be anything from assessing the potential risk of slipping hazards, manual handling activities, working at height, etc. So these pre-existing risk assessments are of course still valid, but there is now a specific requirement to consider all your work activities in the light of COVID-19. And the obligation is to take reasonable steps. Conducting a risk assessment is imperative. You don't need to eliminate all risks in the work activities, but you must do everything reasonably practicable to protect your employees from harm. And this means balancing the level of risk against the measures needed to control the real risk in terms of expense, time, and resources. Now, by way of brief example, if there is a tripping hazard identified on the floor of the workspace, let's say it's a loose carpet, then the balancing of risk doesn't mean that the whole carpet needs to be replaced. You have to take a proportionate stance, and you can just get away with replacing or repairing the area in question. And it should be remembered that employers are required to consult with their workforce concerning risk assessments generally, and particularly with regard to COVID-19. So the obligation is to undertake these risk assessments, and the requirement is that the results of the risk assessments should be published on the website if there are more than 50 employees. So it's the results that have to be published, not the whole risk assessments. Next slide, please. So in terms of identifying potential hazards, the clear potential hazard during COVID-19 is the exposure to and the spread of the virus as a result of work activities. Once potential hazards have been identified, control measures should be considered and be specific to the results of the risk assessment in order to reduce the potential for harm. Next slide, please. So in terms of control measures, examples include ensuring hand washing in accordance with guidance, cleaning and disinfecting of equipment and frequently touched surfaces to reduce the contamination risk. That's one way in which the risk can be managed. I won't go through all of these, as obviously we've got a lot to get through, but clear and concise signage at all entrance and exit points detailing the health and safety procedures. Maintaining social distancing, currently 2 meters, and that may be revised, of course, and control measures would include perhaps one-way pedestrian traffic and floor signs to help people navigate their way around the workplace. Staggering shifts and reducing the number of workers on site is another control measure, and obviously, as we have all been doing, working from home. That is perhaps the first option. And we will also be looking at some PPE related issues, which is normally a last resort in controlling the risks in question. And we're now going to go on to look at a example of a COVID-19 workplace risk assessment. This is potential generic office-based work assessment, and you can obtain some template examples of more specific risk assessments to different types of workplaces from the HSE website. So just to briefly talk about this particular example, on the left-hand side of the form, the potential hazard is identified as contamination through shared facilities. In the next column, one has the potential impact, who might be harmed and how. So the risk of infection spreading through contamination, and it would affect staff, visitors, cleaners, contractors, etc. In the central section, we've got current control measures identified, hand washing facilities, etc. Frequently cleaning and disinfecting equipment and surfaces that are touched frequently, and of course social distancing. Risk level is the next column that's left blank because the competent person, as it's referred to in the Management of Health and Safety at Work regulations, has to complete this form and attribute a risk level score. And I'll come on to show you the matrix in the next slide in a moment. But in the right-hand column, it's a section here for the action to be taken. So let's have a look at the next slide. And this is termed a risk assessment matrix. And it's a traffic light signal, as you can see. Left-hand column is the likelihood of a risk to harm. The severity is on the bottom axis. And basically the competent person who undertakes the assessment has to use his skill and judgment, or his or her skill and judgment, to provide a score. And obviously if the score is in the red figures between 15 to 25, that is a very high risk, and the activity in question should be stopped immediately. Medium risk is the yellow section, and that should only be tolerated for a short term, whilst other control measures are put in place to mitigate the risk. Low risks in green are generally acceptable. So let's go on and look at the next slide, which is another example of a potential hazard risk assessment for workplace access, and this obviously affects all employees, visitors, contractors, etc. The current control measures in the central column, and the actions to be taken in the right-hand column, again with the benefit of that risk matrix, and the assessment made by the competent person undertaking this exercise. A score is attributed to that, and these risk assessments need to be undertaken for all work activities that the company is involved in. Additional control measures may be, so far as workplace access is concerned, perhaps providing additional parking, and perhaps providing some financial help towards travel to work, so that employees can avoid public transport, to minimize the risk of bringing any potential infection into the workplace. Next slide, please. So this is a form that has been made available by the HSE, and is to be displayed in the workplace, confirming compliance with government guidelines. And as you can see, this is a declaration. The employer has to sign the form at the bottom and date it. It has to be displayed in the workplace, and it confirms that these particular steps have been undertaken, and the declaration is that the company is staying COVID secure. Next slide, please. So remote working, employers should continue to remind employees of the Public Health England advice, particularly relating to hygiene and cleaning procedures of equipment and home working surfaces. It's important to keep in touch with home workers and ensure regular contact to make sure that they're staying healthy and safe. Procedures should be put in place so that you can keep in direct contact and recognise any signs of stress as early as possible. And it's not only perhaps signs of work, signs of stress from work that could be picked up, but also potential strains, because if, for example, there's an unusually high workload, or because of the way that the workstation is set up, there is a risk of injury to the tendons in the arms, then this could be an early sign of repetitive strain injury, and steps need to be taken to alleviate any such complaint as soon as identified. And for those working at home permanently or on a long-term basis using display screen equipment known as DSE, employers should engage with them about carrying out home working and home workstation assessment, and there are specific obligations under the DSE regulations. Next slide, please. So in terms of enforcement actions, potential enforcement actions, it's important to appreciate that there is a wealth of different types of action that either the HSE or local authorities can take. They share the duties of enforcement and regulation and assessment between themselves. HSE tend to deal with perhaps more manufacturing industries than local authorities, but there are something like 380 local authorities, each with their enforcement section, and employers may know their local authority enforcement officers, and it's always a good idea to have a good relationship with them, because they can make unannounced visits as well as scheduled visits, and should they find that the work practices have been wanting, then they can issue a notice of material breach. That may be by way of a letter setting out the breaches that have been identified and that they've got particular concerns about. And if that is the case, then they will probably give a timeline within which compliance needs to be fulfilled. If they are concerned on a more with a more dangerous work practice, they may decide to issue an improvement notice. Again, probably giving a strict 7 days to bring that particular activity into line. Or if it's more serious, then a prohibition notice can be issued, and that would bring the work practice to an immediate halt, and that obviously would have serious implications for the business. And there is, of course, some scope for prosecution of the company and or its directors, and the penalties can be quite stringent. There can be unlimited fines, and in the most serious of cases, possible imprisonment. There is also reputational damage to consider, because if the company is on receipt of a prosecution, then it's publicly available, and indeed the implications are obvious for the company. That could be very damaging. Also to be borne in mind is the ability for the HSE to recover what's termed fees for intervention. So this means that once they've identified a breach, they can start charging for everything that they do in order to alleviate that breach. And they charge at £129 per hour. So it's quite easy to imagine that the fees that you could be receiving could be in the thousands very quickly. So it's obviously better to get all your procedures assessed and risk assessments signed off, just in case an inspector calls. Next slide, please. So very briefly, we can help in the drafting of health and safety policies and statements, provide advice in respect of any health and safety investigations, and review health and safety compliance in the workplace at any stage, and also provide assistance with workplace assessments and provide industry-specific advice, and if it comes to it, defend civil claims for damages from employees or members of the public, and also advise on insurance cover and any disputes on policy coverage. So that's all I have to say on that summary. And are there any questions, please?
Yeah, I think we've had a number of great questions coming through, which I can field and pass on to you, Alan, if that's okay. I think one of the questions that's come up is, why do results of risk assessments have to be published on our website? Isn't it just enough for it to be posted on an internal kind of HR system or intranet? Why does it have to be on an external website as well?
Okay, well, it's the obligation set out by the HSE. There's a specific requirement for companies with over 50 employees to publish the results of the COVID-19 risk assessments. And this can be done in a summary form. It doesn't need to be in great detail. It's purely the summary results of the risk assessments, and it can be a simple few paragraphs, 2 or 3 paragraphs, to say that the risk assessments have been carried out in accordance with guidance, and risk control measures have been put in place, words to that effect.
And presumably that's to show both employees and the outside world the kind of steps that the organisation has been taking in that regard.
Yes, precisely. Yes, it's to provide reassurance to the workplace, and obviously they would have been consulted during this process anyway, but also it provides reassurance to members of the public or other visitors with which the company would be coming into contact.
Great, thank you. Not surprisingly, given how many of us are working from home at the moment, questions about employers' duties in terms of the health and safety of staff who are working from home have come up quite a lot just now. Some of the questions that we've just received are in relation to providing desks or chairs for staff working from home. To what extent do employers have to provide that kind of home working equipment for staff?
Yes, I think it really does depend at this stage whether or not the staff is on a long-term or permanent working from home scenario, or short-term. In the event that the staff is dedicated as an office base to work from home, or if the staff are long-term, then the duties are higher from an employer's perspective. They will have to help them through undertaking a workplace safety checklist, and also have a DSE assessment. So that the DSE assessment will take into account the work station itself, the desk or table, and the laptop or computer setup, and that would need to be gone through in some detail. In the event that the employees are on a short-term working at home basis, then a discussion can be had with the employees and advice given about how they can improve their posture. The employees could perhaps take photographs of the workstation to send in, and I know that it's been on the HSE website as a top tip that they can consider using up a rolled up towel, for example, to give lumbar support, or cushioning to raise the seat to a more comfortable and usable height.
Great, thank you. Just before I pass on to Tim, do we have any feel for what long-term kind of means in this scenario? And, you're talking about short-term and long-term. Do you have a feel for what we mean by long-term?
I would I think long term, probably 6 months or more.
Great, thank you very much. We'll pick up, as I said, some of the questions that we haven't had a chance to answer when we send out our answers after this webinar. But now I'll hand over to Tim Hayes, who will be looking at some of the employment issues of returning to the workplace. Tim, over to you.
Thanks very much, Nick. I'm going to presume that everyone can hear me unless I'm advised otherwise. So good morning, everyone. I was interested to hear Alan refer to the Public Health England advice around the cleanliness of workstations. I think after 3 months of homeschooling, I certainly have some work to do myself on that front. So something for me to concentrate on after this after this webinar. So yes, I will be talking about some of the employment law aspects of getting people back to the workplace and what that workplace might look like over the coming weeks and months. And it certainly feels like there is a change taking place in the way that we approach the workplace, where we work, how we work, and how much we work indeed. And really one of the biggest features of our professional lives over the last 3 months has been the rise in home working. And it's going to be quite a transition to make the step change back to the office environment. And it's worth highlighting as a starting point, and Alan did also mention it, obviously the government has produced sector-specific return to work guidance, and I think it's for around 8 different sectors of the economy. And there is return to work guidance specifically for offices, which I'm guessing will be the most relevant for the majority of those who are on this call. And the guidance is basically that people should continue to work from home. Those who can work from home should continue to do so. And there may obviously be certain employees who you might want to bring back before everyone else. So perhaps those who you want to help develop risk assessments or to receive health and safety training so that they can then cascade that to their teams. So those kinds of personnel might be brought back first, but the focus of the workplace, at least for the next few weeks and months, for lots of us, is going to continue to be the home. I think there have been some quite high-profile businesses, national businesses, both in the legal sector and elsewhere, that have declared that they will continue the home working arrangement permanently. Some have declared that they will do so until the end of the year, but some have taken the step and have said that working life will be somewhat different after the COVID-19 crisis passes by. So it really depends on what your approach is going to be. Clearly there is a desire to have some of the benefits of communal working in an office environment whilst retaining some of the family-friendly benefits of home working. Not every employer is going to be happy with having a home working arrangement on a permanent basis. Things that come to my mind are obviously the impact on team working. How do you ensure that your teams interact effectively if you are all in different locations? And that's certainly something, whilst Zoom and Teams are great tools at our disposal, it's certainly no answer to the sort of long-term team working dynamic. And also new joiners, that is also an interesting question that, it's all, I suppose, very well for us as employees who've been with a company for a long period of time. How do you integrate new joiners into a team without an office environment? And of course, there's also the element of trust. Not every employer is going to be happy to have staff sitting at home without some kind of guarantee of input or without some ability to monitor what staff are doing. And I saw in the news, I think it was this week, quite a prominent national audit firm is developing a facial recognition tool to monitor what staff are doing and how long they've been away for their screens. I'm not suggesting for a moment that that's something that you would want to do, but it highlights the importance of being able to have that trust in employees. And not every employee, conversely, is going to be happy with a home working arrangement. You know, quite bizarrely, perhaps the extended period of home working has shown actually how much we value going to the office and interacting with other colleagues and being able to bounce ideas about in person. So there's clearly going to need to be a mix of both going forward. But I think you as employers need to you know, sort out what your approach is going to be during lockdown, what your approach is going to be long term, communicate that to staff, and then update your home working policy. You know, consider actually introducing one if you don't already have one, and assessing, as Alan said, whether staff have the correct types of kit once they're working at home, and risk assessing them as well. So if people must come into the office, your duty is, as an employer, is to reduce workplace risk, as Alan was saying, to the lowest reasonably practical level. So there isn't an obligation to remove all risk for employees, which is some assurance, I'm sure, for employers. So you must undertake your risk assessment, and you must think of strategy. You know, how are you going to comply with or ensure that staff comply with the physical distancing guidelines? Do you have enough space? Obviously, there's quite a high profile mistake by the government, you know, offering to open all schools and then realizing, well, actually there wasn't enough space to do so. So what you wouldn't want to do is repeat that mistake as an employer. Have you thought about how staff will move about the office? And have you thought about how you'll keep the office clean? And as Alan mentioned, have you put up notices in the right place saying the right things? And the public transport element, have you thought about staff, how staff are going to get to the office? And if they need to take public transport, is that a proportionate risk for staff to take? And in terms of the way that people are going to work, do you need to give consideration to shift work, you know, on a daily, weekly, monthly basis? Can you stagger start times? If you haven't considered all these things, then that could come back to bite you in future. It could leave you open to the prospect of tribunal claims, or at least complicate any claims that might be brought. I guess the more in-depth consideration that you give to these issues, and the more evidence that you've done so, the better the position you'll be in to defend claims of discrimination or constructive dismissal or personal injury, etc., etc. So, sorry, if we can move on 2 slides. I forgot to say to move on to the first slide. So let's have a look at vulnerable staff. So clearly, certain groups of people are going to need special consideration with regard to the return to work. And the first category to highlight are those who are defined as clinically extremely vulnerable staff who've been advised to shield. Now, at the start of the lockdowns, I'm sure you all know, the government published guidance on shielding and protecting people who are defined as being clinically extremely vulnerable. And those people were advised to stay at home at all times and avoid any face-to-face contact. And they were notified by letter that they would need to follow rigorous shielding measures for a particular period. And that period was due to end on the 15th of June. It's been extended to the end of this month, and there's currently debate about how long that guidance will be in place for, or might be extended for, after the end of the month. So they've been strongly advised not to work outside the home. The guidelines are silent on what happens when those staff can't work from home. Now, they would be eligible for statutory sick pay, and of course, depending upon their contract of employment or whatever policy you have in place, they may be entitled to enhanced sick pay as well. But you're going to need to approach these issues on a case-by-case basis and take medical advice as well. So those are clinically extremely vulnerable staff. You have also the kind of lesser category of clinically vulnerable staff. They are in summary, those who are 70 or over who have, well, regardless of medical condition, and those aged under 70 with a specified medical condition and pregnant women. And the guidelines suggest that clinically vulnerable employees should be helped to work from home, either in the role that they're doing or in an alternative role. If that's not possible, they should be offered the option of the safest available on-site roles, which would enable them to stay 2 meters away from other colleagues. And if that's not possible, then you as an employer need to carefully assess actually whether coming into work would involve an acceptable level of risk. So again, I think the key probably is to, if you have the luxury of time to do so, seek medical advice. And again, every case will really be different. The third category of, I guess, special consideration staff is those who live with either those who are clinically extremely vulnerable or clinically vulnerable. And the guidance suggests that particular attention, and I'm quoting from the guidance, now, particular attention should also be paid to people who live with clinically extremely vulnerable individuals, but unfortunately the guidance doesn't make any suggestion about what that will mean in practice for employers. Obviously, many people in this situation who share households with clinically vulnerable people may have concerns about returning to work because they might need to use public transport to get there, or because they're concerned about the dynamics of the office environment. So what can you do if someone in this situation, an employee in this situation, refuses to come into work? Well, I think firstly you consider home working or redeployment into a role that might be suitable for home working. But I think you as an employer need to tread quite carefully and sensitively. You could consider allowing staff a period of unpaid leave without any sort of threat of a disciplinary proceedings as a result. You've also got to remember the possibility of, well, the threat of associative discrimination. The law on associative discrimination doesn't protect the relative of a person with a protected characteristic against a failure to make reasonable adjustments. But there is protection against direct discrimination, harassment, victimization. So you've got to be taking reasonable steps to ensure that the employee in question doesn't suffer any repercussions because of their association with a person who has a protected characteristic and falls within one of the vulnerable groups. So what do you do as an employer if someone simply refuses to attend work generally because of fears about coronavirus? Again, firstly, I would recommend that you should consider home working. And if that's not possible, then you would be looking at the current public health advice and the specific reason why this person is concerned about attending the workplace and whether it might be discriminatory to refuse home working or take disciplinary action in this particular case. Could anxiety in and of itself amount to a disability? Again, you're probably best off taking medical advice as to whether that's the case. Now, if it's not, and there's no discrimination angle, and the public health advice is such that the employee could reasonably be asked to return to the workplace, then it's possible that they could be in a misconduct situation because they're refusing to follow what would amount to reasonable management instruction to return to work, and effectively their absence is unauthorised. But my recommendation would be to tread carefully before you take disciplinary action. Obviously, another aspect of this is that if staff are raising health and safety concerns, that might bring in other perhaps whistleblowing issues, which may lead to sort of detriment claims from staff too. So moving on to the next slide. So a few top tips. Obviously, Alan has also mentioned this early risk assessment. and not just risk assessment, but early workplace return strategy. How are you going to organise the return to work? Can you commit it to writing so that you've got evidence that you've considered this? And have you communicated it to staff? Have you got record of doing so? How are you doing this? Is it a web meeting? Is it regular sort of updates, Q&As? You probably need to give consideration to that. And an employment webinar wouldn't be an employment webinar without a reference to reviewing your policies, which is extremely important. Think of the amount of the number of policies that might have been affected by the last 3 months and the way in which we've worked. So you've got your sickness, absence and pay policy. You might have adjusted your notification evidence requirements during the COVID-19 period. Your health and safety policy, you might want to remind staff of the policy and of their duties as to their own health and safety and the health and safety of others. You might want to have a look at updating your disciplinary offences. You might want to include, a failure to observe social distancing, within the disciplinary misconduct definition. So, and also harassment and bullying. You may also want to remind staff, obviously, there is the potential that employees might be harassed by colleagues or customers in the workplace because they're perceived to be at a greater risk of having the virus. And of course, the jewel in the crown in terms of policies in these times is the home working and flexible working policy. I think it's incredibly important now, depending on how you're going to move forward with home working, to update that and make sure that staff are appraised of it. And lastly, dialogue with staff. It's so important to communicate not just these policy changes, but also your intentions moving forward so that they know what's expected of them, and to allay general concerns in relation to returning to the workplace. So I think that those are probably all of the points that I had to make, and that picture probably provides a great segue. Avoid men and instead follow women, and that is a segue, Nick, to the next presentation.
Yep, almost there. Thanks very much, Tim. Some more great questions, and I'll just take a couple now if I can. Yeah, you were talking about employees not wanting to return to work. If, having spent, 3 months working from home, and an employee says, well, look, this just shows that my job can be done in this way, but the employer disagrees. Any kind of tips or thoughts about how you could kind of manage the employee coming back, maybe on a phased basis, or
yeah, I think
like that?
I mean, I guess on the assumption that you've agreed with an employee that the home working arrangement will only be temporary, then I think it's going to be reasonable for you to ask them to come back to the workplace. If they want to continue working from home, then I guess this is flexible working request territory. And you should be asking them to make a flexible working request if they want to make the arrangement permanent. And yes, a kind of middle way, I guess, would be to have a temporary arrangement in place to see how it goes, or a phased return to try and help them. Obviously, we haven't mentioned, we did have it on the slide, but people may have childcare issues, which is going to be a big feature of, probably a big justification for why people want to continue to homework. And I think that's probably going to have to be borne in mind by employers. But ultimately, I think it should be routed via the flexible working request system.
Cool, thank you. We've had a couple of questions as well about proof and whether employers can ask for proof from employees who say that they're vulnerable, or who say that they're living with someone who is, either extremely vulnerable or vulnerable. Do you think employers can ask for proof in those circumstances?
I think they're entitled to ask for the letter, the NHS letter, confirming that they are vulnerable or extremely vulnerable. I guess then the question is whether they're entitled to ask for, data or documents concerning third parties, if they're living with people who are a member of those two categories. I think there may be data protection issues around requesting that kind of information, and I think as a policy you would be able to do that for your own staff. Whether you could do that for those they live with, I would probably stop short of that, and then becomes an element of sort of assessing it on a case-by-case basis. But I would say that you can request evidence from your own staff.
Great. Well, thanks very much, Tim. Right. Well, I'll hand over to Aston in a moment. Obviously, we've got kind of all too used to the furlough rules, so the government have decided to make it even more interesting for employment and HR practitioners, and brought out new guidance to make it more interesting for us. So I'll hand over to Aston Hawkes now, who will look at the new job retention scheme rules. Over to you, Aston.
Thanks very much, Nick. Good morning, everyone, and thank you for joining us. So, as Nick mentioned, I'm Aston Hawkes, and I'm a solicitor in the employment team here at BDB Pitmans. So, I'm going to talk to you a bit this morning about flexible furlough and the new rules that are coming into place. So, if we can have the first slide, please. So, as you will all be aware, the furlough scheme has been changing and evolving since its creation several months ago. And the next phase of this is going to be the introduction of flexible furlough, which I'm going to talk to you a bit about. So last Friday, HMRC published details of the arrangements for flexible furlough, which officially begins on the 1st of July 2020. So though flexible furlough was announced some time ago, there have been some concerns about how this will operate in practice. So there are a number of changes from the existing furlough rules, which I'm going to talk you through. So if we have a look on the next slide, we've got a summary of some of these changes. So you will see from the slide a number of changes from the 1st of July. So first, let's have a look at employees working for their employer during furlough. So as you will be aware, under the current rules, to be eligible for furlough, subject to some exceptions, including employers undertaking certain types of training, employees must not work for their employer during a period of furlough leave. However, unlike under these current rules, with the flexible furlough scheme from the 1st of July, employees are no longer need to be avoiding doing any work for their employer and can instead work for some of the week for the employer and then be furloughed for the rest of it. So what this means is that employers can bring back furloughed employees back to work for any amount of time and shift pattern, while still being able to claim under the Coronavirus Job Retention Scheme grant for the hours which aren't worked. So as Tim mentioned previously, these shift patterns are going to need to be agreed between the employee and the employer, so communication is key at this stage. So secondly, there's a change in respect of the minimum furlough period. The existing requirement is that an employee must be furloughed for a minimum of 3 consecutive weeks on each occasion, and this is going to cease to exist from the 1st of July 2020. So from the 1st of July, there will be no minimum period. However, from a practical perspective, any claim through the Job Retention Scheme's portal must be in respect of a minimum period of 1 week. So in practice, what this means is that you can put in a maximum of 4 claims per month for the 4 weeks in the month, rather than claiming individually for smaller periods of a day or a group of days for each claim. In addition, there's a change in respect of closure to new members. So the government's been discussing for a while that the scheme will eventually come to a close in terms of new entries. So notwithstanding the minimum furlough period, which I just mentioned, from the 1st of July, employers will only be able to furlough employees who have, by that date, so by the 1st of July, already been furloughed for the minimum period of 3 weeks. So what this means is that the last date on which an employer could furlough employees for the first time was the 10th of June, so that they could meet the 3-week requirement by the 1st of July. So the guidance states that from the 1st of July, employers can only claim for employees that they have successfully claimed a previous Coronavirus Job Retention Scheme grant for. And this means that employees must have previously been furloughed for at least 3 consecutive weeks, taking place at any time between the 1st of March and the 30th of June. So what this would indicate is that employees do not need to have been furloughed on either the 10th of June or the 30th of June to be furloughed from the 1st of July onwards, provided that they have been legitimately furloughed for at least 3 weeks at some point prior to the 1st of July. So there is one exception to this condition, and this is where employees are returning from some sort of parental leave after the 10th of June. So these employees in particular can be furloughed from the 1st of July, even if they would be furloughed for the first time at this time. Apart from those employees, the number of employees that employers can claim for in any claim period starting from the 1st of July 2020 cannot exceed the maximum number of employees previously claimed for under any claim ending on the 30th of June. So it's also worth noting that where there are employees who are shielding, which Tim mentioned previously, are those who are clinically extremely vulnerable. Such employees can continue to be furloughed from the 1st of July, but this is as long as the employer has previously submitted a claim for them in relation to a furlough period of at least 3 consecutive weeks, taking place at any time between the 1st of March and the 30th of June. So one final change with the flexible furlough scheme is in respect of written records. So under the flexible scheme from the 1st of July, employers will be required to keep a new written agreement when implementing flexible furlough. So keeping records will not be a new concept for those of you who have already been implementing the furlough scheme, as it's important to keep records to minimise the risks of later claims and obviously for your audit trail purposes. That said, the new requirement aims to bring more certainty on the details of the flexible arrangement so that both parties know where they stand. This is somewhat of a common sense view, because if you've got new flexible shift patterns, then it would be good to have a written record of this that you can then point to at a later stage. Can we move on to the next slide, please? So perhaps the most important change is from a payment perspective. So before I get on to the changes in the grants, I should mention that employers have until the 31st of July to make any claims for periods up to the 30th of June. Then going forwards, from the 1st of July, employers using the flexible scheme will claim from the scheme a pro-rated amount of 80% of an employee's salary, based on the proportion of hours not worked out of normal working hours. So you'll see from the slides, there is a table from the gov.uk website which demonstrates how this will work over the coming months on a practical basis. So you'll see that there's no change in the level of grant for the month of July. However, from the 1st of August 2020, the level of grant that employers can access will be reduced each month. So for August, the government will pay 80% of wages up to a cap of £2,500 for the hours an employee is on furlough, and employers will make employer national insurance contributions and pension contributions for the hours that the employee is on furlough. For September, the government will pay 70% of wages up to a cap of £2,187.50 for the hours that the employee is on furlough. Employers will pay employer national insurance contributions and pensions contributions again, and top up employees' wages to ensure that they receive 80% of their wages up to the original cap of £2,500 for the time that they're furloughed. Finally, for October, the last month in respect of which the job retention scheme will operate, the government will pay 60% of wages up to a cap of £1,875 for the hours that the employee is on furlough. Employers again will pay employer national insurance and pension contributions, and they will top up employees' wages to ensure that they receive the 80% of their wages up to the £2,500 cap for the time that they are furloughed. So wage caps in this respect are proportional to the hours that an employee is furloughed and accordingly will not be working during this time. Employers will have to pay their employees for the hours worked. So those will be the employer's obligation from that stage. They will also continue to be able to choose to top up employee wages. So for anyone who's placed employees on furlough and is topping up above the 80%, that is still possible to do from the 1st of July. So next slide, please. So we've talked through the changes that will be coming into place from the 1st of July. So what should you be doing now? How should you be adapting to the changes going forward? So as I mentioned, the gov.uk website, it's also a helpful tool in terms of providing worked examples on how to calculate employee pay based on the new arrangements. So these are quite helpful, but they're a little bit complicated. So it's definitely worth payroll teams and management having a look at these now, whilst there's time to do so, to get your head around the figures and how that's going to work in practice. You should also start thinking about the kind of shift patterns that would work for your business over the next few months and open these discussions with employees. Communication is key and the best stage to identify any problems before they arise. As Alan mentioned, it's absolutely paramount that health and safety is at the forefront of your mind when you consider your arrangements, because you need to make sure that you have these in place before you start implementing any new shift patterns. You should also review any existing communications with employees. I'm sure many of you have sent out furlough letters previously to some of your employees. So you should review these, consider any dates or any updates that might be needed, and make sure you update these as necessary. Finally, you should consider drafting flexible furlough arrangements and agreements, and make sure that your documents are all in order in case of an audit. That's everything from me. Thank you for listening.
Brilliant. Thanks very much, Aston. We've had a couple of questions on the interplay between the claim period and the number of days that employees can be furloughed for within a week. As I understand it, the 1 week is when employers can claim for their furlough kind of reimbursement from the government, but within that week period, staff can work for as much or as little as the employer wants. Is that your understanding too?
Yes, absolutely. It's a case of just complying with the administrative functions, really, with the grants portal. So just something to bear in mind when you go to make applications, make sure that you've got all of those in your maximum of 4 claims per month.
Yeah, but employees can only work for 1 day during the week and be furloughed for the rest of it. So I think that should be fine. Right, I will now hand over to Brian Gegg, who will look at some of the things you need to think about when you're considering restructuring your workforce. Brian, over to you.
Well, thank you, Nick. Good morning, everyone. I'm Brian Gegg, and as Nick said, I'm here to talk to you about magical beasts and magical tricks, I think, generally, the concept of restructuring. Now, the title slides up there at the moment, and it sort of does what it says on the tin, really. These are deliberate words. What do you do if you need to or you wish to restructure your workforce? And if we pop on to the next slide, now you'll see some questions here, and the real starting point for me is the 3 questions that come up first to ask yourself each time. Number 1, why? Why are you doing this? What is your reason? You need to analyze that question. Number 2 is how. How are you going to restructure? What are you doing? And the third one is way, the way. This is the manner in which you're going to do it, because let's not forget, people often seem to forget this. You're dealing with human beings, and you have to second guess their reactions, and different employees and different groups of staff react in different ways. So you need to answer each of these questions in detail, in advance. Do your thinking. So the how, the why, and the way. And in our 2 dynamics here in the title, we had the other 2 issues on that slide. So some things that you need to do and those things that you wish to do. So you normally need to do something if there's either a cash issue, you must save money, or there's a work level issue. There's less work to do, less demand. And you might wish to do something usually when there's an efficiency issue, so we can do this better, or a shape issue. Our shape could be more dynamic and we are better focusing on more focused on skills. So I think we can pop on to the next slide. Developing a business case. There's a picture of a lion there. I'll come back to it later. So first question, what is your real reason? Now there's two parts to this, and this is a very, very important question because people get asked this in court and they can't remember. So there's two parts to this. There's the reason, what is the cause, and then what is the problem to be fixed, or the opportunity to latch onto. So looking at those two in turn, what's the reason? So, for example, you might need to be saying at the moment, we need to do this because of coronavirus, or we need to do this because we've had some thinking time recently and we realize the business is wrong. Or perhaps we needed to do this before coronavirus, or we're just about to do it, but we didn't do it. It sort of would have happened anyway. So that's really important to go through that process for any sort of change that you're putting in place. And the next one is the problem. What is the problem? This is vital. Don't forget, businesses often miss this. You are entitled to fix your problem. So work out what it is and where it is in your business. And I have to say, so many people and businesses get this one wrong. So, for example, there's quite a difference between you saying we must save 20% of our costs across the business and saying we need less people in the sales department. They're totally different and you deal with them totally differently. Okay, and the next point there you'll see on the slide is developing a business case to match the real reason. So whatever changes you're making or thinking of making, put together a business case and write it down, because it defines many, many things that come later on. And you can constantly refer back to it. It's always your friend if you do it right. So it's worth its weight in gold and is actually essential. So what goes in it in this business plan? And this is for any change you're thinking of making. Number one goes the problem. Yes, surprise, surprise, please tell the staff about the problem. Don't hide it, don't fudge it, deal with it. Number two, why is there a problem? Number three is the proposal that you have for resolving it. You're proposing to do this. You haven't already decided to do this, but you are proposing to do it. And then number four, the process for consultation. And I think a note that the purpose is important. What you're doing here is you're informing employees, you're allowing consultation if necessary, not always necessary, before you decide to do things, and you're matching the resolution to the problem. And businesses do come unstuck here. So you probably say, oh, we'd never do this, but an example, I've seen this live. So if your stated reason is to save salary costs, it doesn't match when you remove a load of managers, but then recruit a lot more juniors who cost the same overall. They're different, and they have to be, the consultation is different. Okay. And this wasn't working on to what are we trying to avoid here? Tim, in any change, Tim touched on this earlier. Constructive dismissal. This is, in this world, imposing change on people. It's changing their status without really realizing. It's a breach of trust. It's a serious, serious breach of your contract to be avoided. Unfair dismissal. Well, this is having a bad reason. And if you've got a bad reason or even a good reason, you've got a bad process. That's why it's called unfair dismissal, because it's flatly unfair to the employees. Then there's discrimination. This is at its most dangerous here, where the business case either doesn't exist or it doesn't make any sense, doesn't stack up, because the courts say there must be another real reason for what you're doing. And we think it's one of the protected characteristics that this employee or these employees have. And not to alarm you, I don't think we'll ever see this in discrimination, but I'm pretty convinced that in these things, somewhere along the line, we're going to see a new concept of people saying, I was once on furlough and now I'm being treated differently to everybody else. So A proper business case cuts through all this, and the reason it does that is because it shows the proper business need of your business and does it properly. Remember also, the courts won't second guess a genuine business decision. They don't look behind that. What the courts don't like is a lack of transparency, a lack of consultation, or a smokescreen. They hate smokescreens. Now, solicitors like us, we're solicitors, we're nice ones. I have to say, if you're going to instruct solicitors on anything in this piece of in this world here, spend it on your business case. Invest the time on getting it right, so you're preparing to succeed. There's another point there called types of change. I'm just going to run through some examples and give you the main bite points or thinking points about each one. Pay cuts. You need a business case for a pay cut. You need consent, really, for a pay cut. And consent is under review. Does it need to be expressed? Does it need to be implied? You're reducing hours or reducing days. That really needs consent unless you can force it through with your contracts, but that's rare. Next one, a proper reorganization. A proper reorganization is where there's no savings to make. You're putting people in different roles, promoting some, demoting some, different reporting lines. That needs a business case. That needs consent, or it needs some sort of selection, interviews, that sort of thing, to be fair. And often closely connected, obviously, to reorganization is redundancy, which has been mentioned. That's where you've got less work or no work of a type, either now or in the future. This is where the business case is crucial again. Why is this happening? And why are you selecting? So just remember, an employee is always thinking, why me? Why is it me that you're picking? So this leads you onto pools and pools of putting people where jobs are linked into one place, and you look for your pool in the area in which you've got your problem. Then there's office or workplace changes. So a number of examples here, some of them have been touched upon. So a change of office use, attend less, operate on hot desk. Does the contract allow it? Do you need consent for that sort of thing? Next one, a change of working conditions. This is different processes to follow. We've learned about health and safety this morning. And post-coronavirus, we might see this a lot. And this is a constructive dismissal issue. There are not many areas of the law that talk about working conditions except TUPE when you transfer across. There'll be more of it. The next one's an office move. You're in the world of relocation clauses. Can you relocate? Reasonable travel, that sort of thing. And a cross-reference into redundancy if people can't move. And workplace closure. We hope this doesn't have to happen to anybody, but this is where a factory or a workplace has to actually shut. That is a workplace redundancy, but you've got to be very careful that you must consult on the closure before you decide to close. So many people don't do that, and they cannot recover from it. And the final one is flexible working. We mentioned that. I think the world has changed dramatically here forever. And watch your old assumptions. I know a lot of you who are on the list out there who we've helped have done reports about your business to help flexible working requests. And for example, you decided for good reason that, for example, help desk can never work at home. That might be different now because they've been working at home recently. So you have to revisit these things. And then my final main point is consultation. Often businesses just simply don't like this. But believe me, it cures all known germs to consult with people properly. What is it? Well, really, if you boil it down, it means giving properly informed employees, they've got the business case, they've got the facts, their chance to make points before you make your decision. They get informed by the business case. When does it end? Well, when there's nothing more to say, really. That could be one meeting. You don't have to do it for months and months, but you have to give the opportunity. And of course, there's various types, and you will all have experience of this: individual consultation, consultation with unions if you have to, if you're unionized, elected reps. I think we're going to see more and more of the need to do this, and I think that will come up with health and safety possibly as well. And collective consultation, Please don't panic about collective consultation. It's not as dangerous and nasty as it looks. Sometimes it can be very helpful, where you've got 20 or more dismissals in a 90-day period in an establishment, and you need to work that out, that establishment point. That's about how your businesses operate and how you run them, and then you need to analyze it and stick with it. And just bear in mind one thing which often goes wrong. What are you using consultation for? Please use it for getting you to the next level or the next stage in your process. For example, if you're changing terms, pay perhaps, you need to get consent first of all. You're trying to get consent. So the first bit of consultation is to get consent. If you're going to go through the next stage of people refusing, and you're going to say, if you don't consent this time, we will dismiss you and re-engage you on these new terms, you start another consultation. It's a different consultation. So go step by step. And then we've got a bit about just do's and don'ts to run through. Some have been mentioned before. First one for me is trust. And this is part of the way. We said the why and the how and the way. If you get the trust of your staff, you can get pretty much anything done. People who are on the side. And they'll be on the side if they understand the stresses and strains of the business. If they're skeptical or they don't see a business case, they lose trust and you lose them very quickly. Next one is second guess morale. You really can't get things like a general pay cut through in this world at the moment unless everyone wants to be all in it together, that sort of concept. And remember, don't jump to redundancies as we must do this. Remember, there's a massive effect of widespread people being at risk when they don't really need to be at risk. They're never the same again. So only do what you need to do when you're analysing things. And don't mix things up. You see it quite a lot. Oh, well, there's a bit of a potential redundancy going on. So, well, Joe Bloggs is not performing very well. We'll throw him in. We've always wanted him out. And we don't like the other guy really, so we get him in there as well. Don't mix them up. You won't win. And also don't hide the problem, as I said before. Be transparent, and don't rush. Everybody wants to rush consultation straight away, and I'm not talking about months and months, but I'm talking about those few days that you need to talk to people. And then finally, be positive. So grab the opportunities to improve your business, not too pessimistic and cutting straight away. I know that's easy to say, but step back and second guess. Magical beasts and where to find them. Well, obviously the precursor to the Harry Potter books, Newt Scamander had a suitcase full of magic beasts, and he was always saying, they're not as dangerous as they may seem. They're actually very helpful. Now, you have that case available to you. You can be positive, and the options that are in there are really not as dangerous as you think or as tricky, as long as you use them in the right way. So step back, plan, unlock the things that you've got available to you. And then there's a picture of a lion. Well, this is our employment line. Some people do know this employment line. We've used it a number of times before, but it's a good analogy really for this period of reorganization. What we're saying in helping you is we know there are dangerous lions out there, but we'll put you on a path to go around them, and we'll go around them when they're asleep or they don't really notice. But if they move, we've anticipated that, and we can steer you around them, distract them, or we can run faster than them to get you to your destination, to get you to do the things that you really need to do. So that was it from me.
Superb. Thanks very much, Brian. We've just had we've had a couple of questions coming through on this topic. You talked about consultation and the importance of that. And we've had a question about kind of what constitutes minimum consultation, and that's probably information, as you say, getting people to, giving them an opportunity to inform the employer of their views before any decisions are taken. Do you think that's right?
That's right. I think if employees have the right information, they can make any points they want, and then you can say, well, that's really interesting. Thank you.
Yeah, absolutely.
And if there's no more points after that, consultation is ended.
Yeah, absolutely.
but it's got to be genuine. You have to consider points that come up.
And how about restructuring and redundancies whilst on furlough? Is that something that people can be thinking about at the moment?
Yes, I think they can. I think a lot of people have been doing this. There's something alien to it about, talking to people about who are on furlough about a restructure. But I think that's best done with the scenario, looking back, why are we doing this? And look, we would have done this anyway, or this is, our business is in a particular shape. This is not really all coronavirus. It's better done for those reasons. And then I think you can do it.
Yeah, I think it's just important to just think about the practicalities of consultation, because we'll be used to having in-person meetings during a redundancy consultation process, but we have to think about now in this new world of doing that by either over the phone or through Zoom or Teams or something like that. But I think again, as long as that consultation is genuine and people are given a reasonable opportunity to give their views and get information about the process, then that should be possible even in kind of this new world.
Yes, and the medium through which you do it might well be a bit of a blocker, because people are supposed to feel comfortable when they're in consultation. This is why a lot of legislation asks you to elect reps, because people feel more comfortable talking through someone than they do going in a room with a manager and putting their view across. So you need to balance that out. I think you need to second guess that sort of concept person by person, really.
And the guidance has been, I think, quite clear as well, that trade union reps or employee reps can carry out their kind of representative duties while being furloughed. So that's not going to be a problem there as well. So the consultation process can get underway. You don't need to wait for the furlough scheme to be over before the consultation process starts. Brilliant. Well, look, thank you very, very much for coming today. Thank you very much for our brilliant panel. You've asked some brilliant questions, really engaged with this topic. It's been really great to see. Thank you also to Melissa, who's been working tirelessly behind the scenes to make sure that everything runs smoothly. As I've mentioned, for those questions that we didn't get a chance to answer today, we will be putting those out in a briefing note, along with a link to a recording and the slides of this webinar, so you'll get an opportunity to watch again or send it on to people who didn't get a chance to an opportunity to watch it today. It's been great, as I said, from our panelists. Thank you very much for joining us. All the very best, and we look forward to being able to see you again soon, and have a great day. Thank you very much.